This podcast is sponsored by Murgitroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgitroyd.com/podcasts.
Welcome to the fourth season of Murgitroyd's Innovation Talks podcast. We're delighted you've joined us. If you have any questions, you can email us at innovation.talks@murgitroyd.com or via @Murgitroyd on Twitter. And please remember to subscribe so you don't miss any future episodes. So let's go straight into today's podcast.
Hi, I'm Thomas Gibb and I'm Director Patents in Murgitroyd Southampton office. I'm joined today by Catherine Bonner.
Hi, Tom.
Okay, Catherine is also Director Patents in the Southampton office and is in fact the office lead.
Oh, fantastic. Thank you for that introduction, Tom.
Today we're going to discuss some common misconceptions about IP. I know we've had thousands of conversations between us about IP over the last few years, and I just wondered what are some of the misconceptions you've heard, Catherine?
Yes, many times people are confused, and understandably, really, in a complex world of intellectual property law, there are misconceptions and misunderstandings. We're here to try and iron out all of those, but many misconceptions come up again and again, and so we thought we'd run through a few today. Yes, in a bit of a light-hearted manner, try and put some of them to bed, hopefully. And I think one of them we often hear is all about disclosure, isn't it, Tom?
Yes, that classic. So, disclosure. I've disclosed my invention. Lots of inventors come to us and say they've disclosed their invention. And what we always ask back is, have you really? So, in terms of disclosure, a disclosure is any time your invention is discussed with the public by written means, by demonstration, presentation, launch at a trade fair, commercial documentation. Those are all disclosures.
And usually we would say, straight off, no chance of a patent application once a disclosure has happened outside terms of confidence.
Certainly so. But there can be a way around this. For an invention to be disclosed, it's important that what is out there is what's known as an enabling disclosure. That means what you have put out into the public domain must be enough for someone else to have create the invention on their own from what you've put out.
And if then there is not enough in the public domain by your disclosure, if there's not a full enough disclosure, if not everything has been disclosed and there's not been an enabling disclosure, then it is still possible.
Yeah, certainly to file a patent application. For example, if you have sales documentation just saying the very outline of an idea, but not the means by which to implement it, then that's not an enabling disclosure and there's still the possibility of filing a patent application.
A patent application for the details of the actual product or process you intend to launch.
Certainly.
Absolutely. Another regular misconception that I've heard through years of helping inventors, startups and owner-managed businesses is that we can't file a patent application yet, can we, Catherine? We haven't actually made a prototype. And this is not true at all. You do need more than just an idea. You need more than a fanciful idea to go ahead and file a patent application. We need a fully completed invention record form. We need a fully set out way that you intend to put the invention into effect, and we need your full disclosure, as we talk about disclosure, full disclosure of what you intend to do. But we do not need a working prototype at all to file a patent application. So no prototype is not a problem. We can still go ahead and file a patent application for you.
Yeah, certainly on that thing, I think it's important to remember that the whole patent system is a bargain, that you tell the patent office what you have invented and how to do it, and they'll give you 20 years worth of protection for it. So all you need in the application is how to do it. You don't need to have done it.
No, I think actually this idea of having a working prototype is a bit of a historical hang-up. I think under some jurisdictions historically, if you were asked to defend your patent, in particular to defend a date earlier than the date of filing, you had to prove that you had done what was known as reduce the invention to practice, which does actually mean making and taking sensible steps to prepare for having a product or a process prototype. But that has long gone. I still think it hangs around, but that's long gone. So no prototype, not an impediment to filing a patent application. So next, Tom.
So my other one that I hear quite is just after filing an application, the client comes back and says, I've got a patent for this.
Yeah, no.
No, it's important to say you have a patent application for this. A patent is you can only say a product is patented once the patent's been granted by the Patent Office, you don't have a patent immediately after filing. It is only an application. And that's an important distinction.
Absolutely. And there's a really lengthy process. It's a long journey. I tried to explain the length of the journey can be 3 or 4 years. There's a long journey from applying for a patent application, going through the search and examination stages to coming out the other end with a granted patent. So we're on a long journey together with our clients.
Yes, definitely.
Okay. As well as I've got a patent, I also hear often, I've got a worldwide patent. And this absolutely is not the case. There are various international systems in place to reserve rights for you internationally. There are certain regional agreements in Africa, Arabian countries, and also across the international patent system. But these are always holding grounds for rights. They're a way of having a patent application really pending in that region. So these include the PCT system for international patent applications, GCC for the Gulf Cooperation Treaty countries, ARIPO, which is the African countries, and probably some I've forgotten. But yes, these are not patents. They are a holding ground for presenting you with a range of countries that you are able to go ahead with at a later date. So no worldwide patent. You can have an international patent application, no problem with that, but you can't have an international patent. Similarly, there is a regional operation of application, search and examination for European patents. That's the European Patent Convention, operating over the European regional phase and extending beyond EU countries. So there are over 42 countries. Thank you, Tom, for that current knowledge. 42 countries available within the European patent system. So really a lot broader and wider than EU countries. This system does provide for centralised application, search, examination and grant. So it is possible for someone to say they have a granted European patent. Absolutely accurate statement. However, in order to bring that European patent into effect and to have rights, active rights in the countries within those 42 that are available, on grant, the European patent must be brought into effect in the countries that you choose. This process is known as validation. It can be quite simple, can be more complex, and we're happy to help with the whole validation process. But if you do not validate your patent in all 42 countries, you do not have a European patent extending into 42 countries. Most commonly, I think my clients tend to validate in about somewhere between 5 to 7 states. I think some of yours might do a few more, Tom.
Yeah, I've done one for 35. I think that's the most, but generally, as you say, between 5 and 10.
Yes, yeah. So worldwide patent, no, inaccurate statement. European patent, yeah, could be. So yeah, that's a reasonable statement to make. And moving on, Tom, next one.
So another one we hear quite a lot is, I can make the product because I have a patent for it. And that's not necessarily true.
No, a bit more complex.
So with this, it's important to remember here that a patent is an exclusionary right. A patent prevents other people from making your invention. It doesn't allow you to make your invention yourself necessarily. So, for example, if I had a patent for Wi-Fi in general, just out there, a general concept, then Catherine later obtained a patent for long-range Wi-Fi, Catherine wouldn't be able to make her long-range Wi-Fi unless she'd obtained permission from me in the form of a license or an agreement to operate within the scope of my patent. But similarly, I would not be able to sell long-range Wi-Fi unless Catherine had agreed that I could do so. So Catherine is able to exclude me from her portion of the market, and I'm allowed to exclude Catherine entirely. The patents themselves are used to stop people doing things and not allow people to do things.
And in commercial reality, really important to carry out freedom to operate checks before going ahead with a new product or process launch. We have experience in freedom to operate analysis and searches, done those for very many clients, and often this licensing and cross-licensing is the way out of that sort of situation. But yes, that's a really tricky area, and we do get that comment raised quite often, and it's a nuanced argument that we have to run through and explain it. But yes, thank you for that. The final one I have on this list that we've been talking about, Tom, is something away from patents, which is I have less experience of, but the trademark and branding world often has a lot of misconceptions as well. Very happy to discuss branding and new product launches. But one thing that we have a lot ahead of new product launches is people saying that, well, I have my company name registered at Companies House, so I've got a trademark, haven't I? No, Companies House and the registration and setting up of a new company is a necessary step, but is entirely separate to securing intellectual property protection. So really, whatever you've got at Companies House is one thing, it doesn't provide you with any IP rights at all. And that's a separate trademark application and registration process, which will need to be gone through for brands, house marks, names, product names, and things like that. So another misconception there. And I think we'll leave it there for today.
Sounds good to me, Catherine. Thank you very much.
Thank you, Tom.
Thanks for your time today. We hope you found today's podcast valuable. And remember to subscribe so you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgitroyd.com.